Howdy, Facebook Live. Sean Yesner here. So I need to create some more content for the Crushing Debt podcast. So one of the topics that I'm going to cover today is the difference between Chapter 7, Chapter 11, and Chapter 13. I get questions on all three of those bankruptcy chapters, and I've done a little bit of blog posting about it, but when I went back and searched, I had no podcast content specifically to that question. So I thought I'd do an episode here about that. I think that this will be the first episode of 2019 to be released. I still need to record one episode for the end of 2018, which I think I'm just going to do a year-end wrap-up episode for 2018. I don't know if I'm going to do that one live or not. So thank you for the people that are tuning in. What I'll do, like I've done the last couple of Facebook Lives, I will record the podcast episode and then I'll come back and answer your questions. So if you have a question that you want me to answer, I'll do that after the recording of the podcast episode has stopped. A little bit of Facebook Live love for the people that tune into Facebook Live, a little bit of bonus content for the people that tune into Facebook Live. So with that, let me get started here on the podcast recording itself. And if you have questions, go ahead and type them in. And when I'm done, we'll get to those. So without further ado, here we go. On this week's episode of the Crushing Debt podcast, what's the difference between Chapter 7, 13, and 11? So welcome back to this week's episode of the Crushing Debt podcast. My name is Sean Yesner with Yesner Law. And as I've said for the last couple of weeks, this week's episode is not only brought to you by my law firm, but also by the book that I wrote called Crushing Debt. You can find that book on Amazon.com under Crushing Debt or under my name. And the book goes into a lot of the topics that I cover here on the show. And also, I'm working on getting the electronic version, the Kindle version, out to you all as well. So look for that in the next couple of coming weeks. But I definitely encourage you, go online, check out the Crushing Debt book on Amazon.com. So one of the questions that I talked about, one of the issues that I talked about in a previous episode was the difference 13 when we're talking about bankruptcy. And what I realized was I've done a little bit of writing on the topic, but I haven't yet done a podcast episode related specifically to that subject. So here we go. This one is for you. Those of you that say, what's the difference between 7, 11, and 13? That's what I'm going to try to explain here on this week's episode of the Crushing Debt podcast. So Chapter 7 is called a liquidation. Sounds pretty simple. So we're going to take the assets of the debtor that are not exempt. We're going to turn those assets into cash, and we're going to pay our creditors. So the main issue behind a Chapter 7 is we want to try to exempt all of our assets so that there is nothing to pay to the creditors. And basically, the creditors go away for zero, and the assets are all exempted or all protected. Now, in a case where there is an asset that has some value that is not exempt. Think, for example, if you own a small business and your small business has some type of value. So that would not be an asset that we could exempt. Or think if you had some expensive jewelry, or if you had an inheritance, or if you had some money saved up, or if you had stocks or bonds saved up that are not retirement accounts. And so those are all not exempt assets. And so what the trustee does is, if they're able to convert some of these assets into cash, they use those assets, they pay back the creditors, and the creditors go away. So let's take, for example, if you had a diamond ring that was worth $5,000 and you had no way to exempt that diamond ring, all your other exemptions, all your other protections are used up. So the trustee is going to say, if you want to keep that diamond ring, pay me $5,000. Now, in some cases, necessarily have to pay them $5,000 if we can settle with them, or sometimes maybe we can settle with them on a payment plan. So once the trustee gets the money from that asset, in this case, let's assume $5,000, if they then have $50,000 worth of creditors who file claims, your creditors are getting paid 10% of what they're owed. They're owed $50,000. The trustee has an asset worth $5,000. They're getting back 10% of what's owed. Now, a lot of people will say, if I had 5,000 laying around, I wouldn't need to file a Chapter 7 bankruptcy. And you're absolutely correct. And that's where we get into the payment plans with the trustee. That's where we get into maybe negotiating with the trustee. So even though you might have a $5,000 asset, maybe we can negotiate with the trustee to pay the trustee $3,500 or $4,000 or something along those lines. And so that would be a great way to settle with the trustee to pay less than what's owed. Now, one thing I hear a lot, because sometimes this conversation comes up in the terms of a car. And so, we have a car that's free and clear that's worth $4,000 or $5,000. And so the trustee will say, you only get $1,000 exemption for your car. And so if your car is worth $5,000, you get your $1,000 exemption. Give me $4,000 or give me the car. And a lot of people say, well, wait a minute, I need my car to get to work. Here's the problem with that analysis. Here in Florida, Florida says you get a $1,000 exemption towards your car. Florida has some of the best real property, homestead exemptions in the country. They have the worst personal property exemptions in the country, in my opinion. So if the trustee says your car is worth $5,000, you get a $1,000 exemption. You have $4,000 that is non-exempt. Give me your car or give me $4,000. At that point, the borrower, the debtor in bankruptcy, will say, well, I need my car. I need my car to make a living. I need my car to get around. I need my car to do this and that and the other thing. And while that might be true, in this case, in Florida, it's the job of your bankruptcy attorney to say to you, hey, if we file the bankruptcy in this way, your car is at risk. Let's find another way. The trustee will not take kindly, the court will not take kindly to hardship. Or to put it another way, if you say, I have a hardship because I can't keep my car, the judge and the trustee is always going to counter and say, your creditors have an equal hardship in that they're getting less than what they're owed and they're not able to collect the remaining balance from you. So in our area, the trustees get it, the judge gets it, but I don't know that hardships hold very much weight in Tampa, in the Middle District, and probably in a lot of bankruptcy courts around. Because, again, at the end of the day, for every hardship that the borrower might face, for every hardship that the debtor might face, the counter argument is always your creditors are going away for much less than what's owed. So to the extent you have a hardship, someone else, the creditor is going to have an equal or greater hardship. So that's basically how a Chapter 7 works. The other side of the coin there is a Chapter 13. So it's very much the same analysis, because in a Chapter 13 case, you cannot file in such a way that your creditors would be treated worse than if you had filed a Chapter 7 case. That I explain a Chapter 13 to a client is, let's take that same example, the $5,000 ring, the $5,000 car, the asset that you're going to have to pay money to the bankruptcy trustee. Well, in a Chapter 13 case, you still pay that money to the trustee, but you pay it to the trustee over the life of the bankruptcy plan. You pay it to the trustee over the life of the repayment plan, normally 36 months, 3 years, 48 months, 4 years, or 60 months, 5 years. And so again, you take that $4,000 of non-exempt equity and you pay it over to the bankruptcy trustee. And if you do that over 60 months, we're paying about $67 a month towards the unsecured creditors in a 60-month Chapter 13 plan. If you pay that $4,000 back over a 36-month bankruptcy plan, we're paying a little bit more than $100 a month towards the bankruptcy trustee under that bankruptcy plan. And so that's one way that we can pay in a Chapter 13 plan. But remember, a Chapter 13 is also called a reorganization. So what does that mean? Well, one of the other tests that the trustee will look at is the means test, or your budget. In other words, if you have disposable income at the end of the month, the trustee is going to require that you pay that disposable income to the trustee to repay your creditors. So how does that work? If you have, let's say, $300 left at the end of every month, the trustee is going to say you can afford to repay $300 a month towards your unsecured creditors. If you have $50,000 of unsecured creditors, $300 a month for 60 months is $18,000, and you're going to have to pay $18,000 to that $50,000 worth of creditors. And if I do my calculations correctly, you're paying about 36% in that example. So your creditors go away after paying 36%, 18,000 on 50,000. Now, what about, I just said earlier that if you have an asset that's not exempt, that asset, the value of that asset must be paid to your creditors over time in the course of a Chapter 13 reorganization plan. And that is still true to an extent. One of the advantages of Chapter 13 is that if you have an asset that is over the allowed exemptions, you can keep that asset as long as you pay the creditors for it. So if you have that $5,000 ring, that $5,000 car, you can keep those assets as long as you pay the creditors for the value of that car. But here's the beautiful part of the Chapter 13. The trustee is going to look at which of these tests pays the unsecured creditors more money, and then they're going to go with that test. So in my made up example, we have a $1,000 car or a $5,000 ring versus $18,000 of income over the life of the plan. The trustee is going to pick the income and say, you need to pay me pursuant to your disposable income, that $300 a month that you have extra laying around. Now, one of the downsides of a Chapter 13 is that the trustee is going to require that you submit your tax returns every year and that you pay your tax refund every year to the trustee. And the reason that the trustee does that is that they want to analyze, what is your income doing? Is it going up? Is it going down? If your income goes up, the trustee may require that you pay more money on your bankruptcy plan because your income has gone up. If your income has gone down, there's an opportunity there for us to ask the bankruptcy court to reduce your payments on an annual basis once we get your tax returns. Now, it's not a dollar for dollar. So if your income goes up such that your disposable income goes to $300 a month up to $350 a month, I don't think the trustee is going to say your payments need to increase by $50, but be prepared. The trustee is going to say your income needs to, your Chapter 13 plan payment needs to increase. By the same token, if your disposable income goes down from $300 a month down to $250 a month, we may not be able to say that we need a $50 reduction in our plan payments. There may be other factors in there in terms of administrative expenses, trustee expenses, creditor expenses. Are our creditors priority creditors like the IRS, or are our creditors just general unsecured creditors? Or are they related to a mortgage? Did we get the mortgage modified? All these other factors factor into it. So a lot of times what I tell my clients is the distinction between a 7 and a 13 is important because we need to know the underlying goal of the bankruptcy trustee. In a Chapter 7, the underlying goal is to liquidate assets to see if we can pay off creditors. Now, in both cases, we need to be an open book. We need to be 100% honest with the bankruptcy court, with the bankruptcy trustee. But think about the motivations for a bit. If the Chapter 7 trustee is interested in liquidating assets, we need to be really, really specific on the value of those assets. We also need to be specific on the value of the assets to the Chapter 13 trustee. But remember, the Chapter 13 trustee gets paid based on your disposable income or the value of the assets. So while we need to be honest on the value of the assets for the Chapter 13 trustee, as long as we can agree on the payment that needs to be made to the Chapter 13 trustee, and our valuations of our assets are proper or are reasonable, then the specific value of any individual asset becomes less relevant. So I'm going to try to say that again to make sure that I'm clear here. We need to be 100% honest in our petition. We need to be 100% honest when dealing with the bankruptcy court and dealing with the bankruptcy trustees. But know that the focus of the Chapter 7 trustees is what assets can I convert to cash and pay creditors, where the focus of the Chapter 13 trustees is, are you making your payments to repay your creditors? And so that's the difference really between a Chapter 7 and a Chapter 13. Chapter 7 may be a bad idea when you own jewelry that you might have to liquidate, family heirlooms, that kind of stuff. Chapter 13 is definitely a bad idea when you have an inheritance coming in. Chapter 7 is definitely a bad idea when you own a business, because what is the value of that business? Now, I've said multiple times that the value of the business becomes an asset of your Chapter 7 bankruptcy, and we cannot value businesses at $0. So take Yesner Law, for example. Someone would say, well, if I decide to retire, Yesner Law is worthless. But that's not true, because Yesner Law owns desks. It owns computers. It owns a conference table. It owns a client list. It owns the Crushing Debt podcast. It owns the Crushing Debt book. Yesner Law has assets. It owns a website. It owns a blog. It owns all of these different things that give it value. Now, that value may be $1,000 or $5,000 or $10,000, but the value of Yesner Law is based on a lot of those intangible assets or tangible assets, the furniture, the fixtures, the goods, the client list, the customer list, the form documents, the form banks that I've built up. All of that stuff goes into the value of Yesner Law. And so we cannot say Yesner Law is worth $0, even if it would be to the point where shutting down Yesner Law meant the firm just dies a natural death because it's only got the one attorney, which, by the way, I've got news on that coming up as well. But if Yesner Law dies a natural death because it's only got the one attorney, it still has some value. There may be other attorneys who want to come in and buy the practice and take over the practice and continue the practice moving forward. So a Chapter 13 is a bad idea in a situation where your assets are more than your disposable income. If you've got assets worth $50,000, but your disposable income over the life of the plan is only going to be $18,000 or $20,000, $250, $300, $400 a month, a Chapter 13 may be a bad idea. A Chapter 13 is a bad idea if you don't have regular disposable income, because you need to have income to fund this Chapter 13 plan. And so that's a situation where Chapter 13 might be a bad idea. So you need to be aware of the differences. You need to be aware of the pros. You need to be aware of the cons. These are the things that you need to discuss with your bankruptcy attorney before you make the decision to file bankruptcy. Now, I did mention a third chapter in the introduction, which is Chapter 11, which I'll get to here. I am filing Chapter 11 cases now. I have learned about them. I shied away from them in my earlier days because, a lot of people say, well, a Chapter 13 is just a very complex, or I'm sorry, a Chapter 11 is just a very complex Chapter 13. And to those people, I say that's not really true. So Chapter 13 and Chapter 11 are both reorganizations. Chapter 13 is limited to individuals. So only a person can file a Chapter 13. If an organization, an LLC, a corporation, whatever, wants to reorganize its debts, it must file a Chapter 11. An individual can file a Chapter 7, but also a business can file a Chapter 7. So we don't really have that conflict of, should I file 7 or 11? If you're a business, you file 11 if you want to reorganize. You file a 7 if you want to shut it down. There is another way that a person could file a Chapter 11. So Chapter 13 has jurisdictional limits. There is a limit to the amount of secured debt and unsecured debt that you can have if you want to file a Chapter 13. And so I don't recall, but I believe the secured debt is $1 million, 1.1 million, something in that range. In other words, you have to have less than that in secured debt in order to file a Chapter 13. And the unsecured debt limit, I believe, is around $400,000 to $450,000. In other words, you need to have less than that amount of unsecured debt in order to file a Chapter 13 case. And those amounts are changed every couple of years to reflect the economy. And so don't quote me on those numbers. If you're curious about those numbers, shoot me an email and I'll send you the exact numbers as of the time that you're listening to this episode of the podcast. But if we have someone who cannot file Chapter 7 because they make too much money, or cannot file Chapter 7 because they have too much in assets, and we cannot file a Chapter 13 because they're above those debt limits, then we file a Chapter 11. Chapter 11s are a lot more complex than Chapter 13s and Chapter 7s. They are typically a lot more expensive than Chapter 13s and Chapter 7s. But at the end of the day, a Chapter 11 is a reorganization just like a Chapter 13. So, the way that these things work, if you are an individual or a business that wants to liquidate and pay off your creditors based on the non-exempt value of your assets, you're looking at a Chapter 7. If you're an individual that wants to reorganize you're looking at a Chapter 13. If you are a business that wants to reorganize, you're looking at a Chapter 11. If you're an individual who is above the limits required to file a Chapter 13, then you're also looking at a Chapter 11. And so those are the big differences. That's the 50,000-foot overview of when might someone want to file a Chapter 7, a Chapter 13, or a Chapter 11. A lot of people get confused and walk into my office and say, I want to file a Chapter 11, when what they're really talking about is they want to file a Chapter 13. So it does get confusing, but that's why I want you to come to me with these questions. That's why I want you to rely on me, rely on your bankruptcy attorney to give you that advice as to which chapter applies and then how does it work. So there you have it. So that is it for this week's episode of the Crushing Debt Podcast, the differences between Chapter 7, Chapter 13, and Chapter 11. If there's other topics out there that I haven't covered, please connect with me on social media. Please send me an email, let me know, and I will cover those topics for you as we get further into 2019. But like I said, that is it for this week's episode of the Crushing Debt Podcast, and I look forward to talking to you in next week's episode. Okay, so Facebook Live, thanks for sticking with me. We are done with this episode of the Crushing Debt Podcast. Let me just get it set up so I can save it here, so I can get it engineered, so I can get it up for you. This, I think, is going to be 147, Chapter 11, and let's see, Chapter 7, 13, 11. So I will get that saved here in my Dropbox folder so we can get it engineered for you. That is going now. And so I don't think we have any questions, it looks like. I know Mike Watkins said hello. Mike, if you're still watching the Facebook Live feed, happy birthday. Michael Watkins and I have the same birthday. My birthday is December 15th. So as I record this just a few days ago, and Michael and I share a birthday. So I am happy to share a birthday with you, Michael. Happy belated birthday. Other than that, if we have no other questions, it doesn't look like anyone's on Facebook Live. That is it for this week's Facebook Live episode. Thank you all for tuning in. When I get the podcast episode uploaded, I will upload this one to YouTube as well. Thank you all for tuning in. If you have questions, please let me know. Please connect. And I will probably go live the next time I record an episode. As I record the year-end episode here, I probably won't Facebook Live it, but I will Facebook Live when I record another episode. Look for guests to be in the studio. I did mention in the podcast something about an associate attorney. I did hire an associate attorney. Her name is Tiffany. You guys will be seeing and hearing from her as we get into 2019. Right now, she's asked for, and I've given her time off so that she can pass the February bar exam. So as soon as she does that, I'll be and doing podcast episodes and whatnot with her. But that's all for this week. Thank you all for tuning in, and I appreciate all of your support, and have a happy new year. Have a happy holiday, a Merry Christmas, Happy Hanukkah, whatever you happen to celebrate, if you happen to celebrate. And we'll catch you next time. Thanks a lot.